a good day to everyone. Welcome to the Evolving Liability Virtual Conference 2020. So the theme of the conference is liability trends in a transitioning world. Just a few words to explain this title and the selected topics. In general terms, we can describe the transition as a continuous transformation of the existing towards something uncertain. Therefore, if we want to predict the next steps of this ongoing process, the more we understand the drivers of transformation, the more our exercise will be successful. The purpose of this conference is to understand the dynamics of three topics having a relevant impact on the insurance industry. These topics do not arise from scratch, but are the evolution of events that have existed for some time. We want to assess how they impact the liability of customers, policyholders, and implications for insurers, having in mind that a pandemic is underway. So the next slide, I think, displays the three sessions and the outstanding discussants who kindly accepted our invitation. So the first panel deals with the dynamics of social inflation in light of the pandemic. We do not have a legal definition of social inflation. It's more a buzzword used by insurers to describe the rising costs of insurance claims over and above the general economic inflation and resulting from things like increasing litigation, broader definitions of liability, and larger compensatory jury awards. Social inflation is mainly a US phenomenon, but there are signs of international contagion, especially in securities litigation and associated D&O insurance. I'm sure discussants will provide valuable information on the current dimension of this phenomenon, as well as the differences from past drivers, also in the light of the pandemic. The second session deals with the climate litigation risk. A few numbers to introduce the topic. There have been almost 1,400 climate-related litigation cases around the world, and the number of cases since 2016 has risen sharply. More than 1,000 have been in the US, and most corporate cases involve defendants in the energy and natural resources industry. The outstanding panel of the session will address issues such as the characteristic of climate litigation landscape, the drivers to a global expansion of this risk, but also challenges and opportunities of climate change litigation for insurers, taking into consideration physical and transition risks. The third session is on artificial intelligence and liability regimes. We use the plural regimes. I'm at providing an updated overview of the European Union and United States approaches to artificial intelligence and liability. Harmonization of rules in these jurisdictions is a goal of regulators, and therefore the use of the plural is related to legal liability regimes for artificial intelligence that are currently not harmonized at EU level and US federal level. I'm sure that discussants will provide examples of the potential implications the legislative proposals may have on the insurance industry. After this overall presentation of the topics, some final words on the structure of the sessions. Although the conference is held virtually, we will try to be as interactive as possible with the over 100 people registered for the event. A 15-minute Q&A follows each session, and there will be some poll questions launched during sessions. Technical reasons, however, do not allow verbal interactions from the audience. You find the chat function on your screen. You can start writing the questions in the chat from now on. I will select the relevant questions and submit them to discussants during the Q&A for each session. If there are too many questions, don't worry. Each of them will be answered in the next few days by the person chairing the session. So now let's start with the first session on the dynamics of social inflation in light of the pandemic. Darren Payne, who is a financial economist and external consultant at the Geneva Association, with the past professional experiences at Swiss Re, Bank of England, the European Central Bank, will chair the session and introduce the outstanding discussant together with the topic. Darren, the floor is yours.
Thank you, Pierpaolo, and hello to everybody online. It's my pleasure to chair this panel. We've got a really great couple of speakers and discussants for this session. First off, we've got Chiara Brady, who is currently Global Head of Liability at Allianz Global Corporate and Specialty. Chiara has got deep expertise in underwriting, having worked previously at both Chubb and Swiss Re. So she's going to have both a perspective from the primary insurance side, but also the reinsurance side, I'm sure. The second speaker is Damon Vocker. He's currently a partner and head of regulatory insurance at Duane Morris, an international law firm based in the States. I saw on his website he's a seasoned trial lawyer and business counselor, so it'll be interesting to hear a bit more about some of that in relation to social inflation. But he's got a particular focus on complex insurance and reinsurance coverage. And not only is he now an outsider, he also used to be an insider, in the sense that he used to work for Gen Re as their general counsel. So he will provide an inside and outside perspective, I'm sure. In terms of how I want to organize the session, I want to unpick the title somewhat. And I think it lends itself to thinking about this in three different sections. One, to kind of bottom out what we mean by social inflation. Secondly, to think about the dynamics element, and ultimately to come on to a topic which is probably front of mind for everybody, is to think about the pandemic. But before getting into the meat of the discussion, I just wanted to reinforce the technical or the poll question that we're anticipating having in the middle of the session. So at some point within the session, there'll be a slide pop up on the screen which will give participants notice of access to a Mentimeter website where you can go on there, log on, and be prompted by a code, and that will come on screen. And then we'll hopefully, it takes a bit of a while to process, but we'll hopefully can be able to kind of reflect on some of the results from the audience and get a bit more interaction. Okay, let's start off with my first kind of topic, and welcome to Chiara and Damon. I mean, every time I talk to someone about social inflation, I'm always sensed that we're not quite always talking about the same thing. And that's often, maybe it's because they're different sectors, but I wanted to start by maybe just getting the panelists sort of their own thoughts about how they define social inflation. What is it and how do they go about thinking about it? So maybe we'll start off with an insurance perspective first, and then with Chiara, and then come for a lawyer one from Damon. You're on mute, I think, Chiara. Still on mute. Well, maybe we'll switch it around then. Maybe we'll go for Damon's first for the legal perspective, and hopefully in that time some of the technical glitches we have with Chiara will get resolved. So Damon, the floor is yours. What does social inflation mean to you?
Yeah, well, social inflation are outcomes that I believe are relative to business people in the industry, irrational outcomes that are disproportionate to the amount of damages that are in question in a particular dispute. And it's really an increase. We've seen there's been cycles of this since the 1970s, an increase in the frequency and severity of jury outcomes and claims outcomes and lost adjustment outcomes. But really, some people refer to them as nuclear verdicts or runaway verdicts, but they are economic outcomes that we believe from a business standpoint are far greater and disproportionate to the actual injury in question. And I know we're going to get into what's causing these kinds of things, where we are today, where we've been in the recent past, and where we're going with COVID-19. But that's really where we are, and insurance is an industry of predictability, pricing and reserving. It's really the business model is the ability to appropriately and rationally estimate your loss exposures. And with the advent of this phenomenon of social inflation, becomes much more difficult for underwriters and actuaries and executives to evaluate the loss exposures that they have that they're putting on the books, particularly on long tail exposures, of how this is going to impact the book and how then in turn it impacts the pricing on the front side of the business with this phenomenon, which we have all CEOs of the major companies have been talking about it in the recent years. But now we're in a completely different paradigm with COVID-19, which is where is this going to happen? The courts have basically been frozen out because of the closure of all kinds of non-essential businesses, the logistical problems of having people attend court and so forth. So we're in this limbo or interim period here where we're not able to assess whether and to what extent COVID-19 is going to exacerbate the pre-existing social inflation conditions or whether it's going to remain status quo of some sort. So we do have these trends. One of the things that I think the industry has been grappling with is the aggregation of industry data so that it can properly track this and build it into its actuarial pricing and reserving components as it attempts to track the business, but also, and that's driven really by the claims results. And then, what business in terms of risk selection do these companies on the direct and reinsurance side want to target, and if so, at what price? Given these pops, if you will, at least in the U.S., refer to them as outcomes that are unexpected, unforeseeable, and disproportionate, again, to the reasonable estimation of where we think they're going to come. So that in a nutshell is, I think, what the challenge that the industry confronts is evaluating what it is, what the extent it is, and then how do you build it into your operational practices and anticipating what those loss exposures may be so that you can have appropriate risk selection.
Interesting. Chiara, do we have you online now?
I hope so.
Perfect.
Okay, great.
Well,
super. Thank you so much.
Maybe we can get your perspective. And Damon's just outlined from kind of a legalistic perspective, but also touched a little bit on the insurance side as well. Maybe we could get your perspective from a kind of insider insurance perspective.
Mm-hmm. Okay, so I think as Amadeus Pierre-Paolo said at the beginning, social inflation is often sort of a buzzword that we hear quite frequently in the insurance world right now. And I think there's two different views on what it means, right? So the simplistic view that is not supported by insurers is that it's just an excuse for underpricing. I don't believe that's true. It's really this phenomenon that we're seeing that's coming from a number of different things, but the main one being an increase in claims costs, right? Mainly in the US. And what is driving that? I'm sure, Damon, you touched on this. We have litigation is a major factor. And then the broadening of the definition of liability. We often hear of situations where there's a disagreement in whether or not something is covered and what the intent of the policy was. So that is something that is happening, I think, more frequently than in the past. And then we have plaintiff-friendly courts, and we often hear reference to a plaintiff-friendly state or jurisdiction in the US. And then, of course, social media and the ability for large case verdicts to be shared broadly, globally to everyone. And in the past, that didn't happen. So people are much more aware of the size and types of settlements that are taking place. When you wrap all of that up, when there is a situation where injury occurs and someone needs to be compensated for it, the expectations are growing. And that is essentially what we see as a very simplistic definition of social inflation.
So just to try and to kind of connect the two between Damon and Chiara, in terms of how do you, even if you kind of got a sort of pseudo common definition, one of the issues that I always struggle with is knowing how much what we've seen recently in terms of maybe like outside claims, how much that's a sort of permanent change. So there's a sort of underlying trend has changed, and so we've moved to a world where claims are accelerating and are growing at a much larger rate, a higher rate than perhaps insurers had either foreseen or certainly priced for. So how do we get about, so it's kind of moving from the definitional, but also to the measurement. How do we know what the underlying kind of trend is for some of these claims? How does that kind of take place? Maybe I'll direct that to Chiara and then come back to Damon.
It's a challenging question, one that I think all insurers on the phone are asking, because we don't know for certain what the impact or what the claims trend directly linked to social inflation is. What we do know is that it's something that has been more prevalent in the United States since 2018, maybe 2017. And so we see a definite uptick in our claims costs, so we can calculate what the claims trend is. Now, the second part of that question is really, is it a long-term trend or is it a short-term trend? And that's what we don't know. If you look, I saw a publication the other day, I think from 2016 to 2020, we're up into the double digits, but over a longer period, we're still at quite a low claims trend. So it's the magic question. I do not know the answer.
Yeah. Damon, do you have any thoughts on that?
Yeah, I think an industry, an interesting outflow of the concept of social inflation is not just the formal jury outcomes and nuclear verdicts and all of that, and we've all seen those in our and when I was general counsel as well as outside counsel, I'm sure Ciara's seen it as well. You have these pops and they're unpleasant to discuss in your quarterly reserving meetings, and there's a lot of discussion about why it happened and could there have been something done to prevent that. But the psychological or intangible component of this phenomenon, I believe, is embedded in these organizations where there's a greater tendency, I believe, within the claims departments and those that they report to avoid getting to trial with the fear that we might have a pop. And so the settlement values, when plaintiffs' lawyers have become more aggressive, recognizing this phenomenon, they are putting greater pressure on insurers with higher dollar values for settlements that in prior years preceding this phenomenon, I think management would say that that's crazy. We're not going to settle for that. We'll try the case. And they'll come down. And a lot of plaintiffs' lawyers now are not coming down, and they're willing to roll the dice and high risk, high reward. And it's having this psychological component on people that are responsible for making the decisions that if, even though it's painful to cut a check and settle a case or a claim, they're worried. It's a human psychological component that they're going to be accountable for the outcome if it's adverse. They'll look like a hero if it comes out well, but if it's a pop, as we all know, and executives sitting around in a room, there's accountability. And it's, why did this case go to trial? What did we do to try to settle this? And so that there's a fear factor, I would say, among claims professionals and those that they report to, that we need to try to get some of these cases settled where there is at least a possibility, if not a probability, depending on the jurisdiction, mostly in state courts, that this could end up with a very large outcome that could really undermine a good quarter of underwriting results, for example. And so those settlement values, I would say, in general, there's probably an increase in those, again, relative to the pre-social inflation years where the insurance companies were more bullish, I think, to challenge these claims when they appeared to be irrational, thinking we'll go to court, we'll take an appeal, we'll fight. And I think there's more of an inclination now to try to get those cases resolved, even though it's painful, even though the check is bigger, to make that go away. And I think that's something that the industry is struggling with is, does the industry continue to fight back against this phenomenon, and gird itself for some bad outcomes versus being more liberal, if you will, in settling claims at higher values, with the expectation that's just going to feed momentum on plaintiffs' bar to push for those higher numbers. So there's a real dilemma there, I think, in terms of institutionally, how do you handle these types of potentially high exposure claims without opening up your checkbook and inviting other types of claims with high settlement values associated with them?
Yeah. I mean, Damien, you put a lot of store on the kind of aggressive tactics of the plaintiff's bar. Do I take from that that you think that's the sort of primary driver at the moment? Or are there other things that could well be adding to that sort of toxic cocktail?
Yeah, I think there's a variety of factors here. Attorney advertising pays off. I mean, if you look at the return on investment, I believe the ABA has reported that the attorney advertising is over $1 billion a year. The lawyers in this business are getting better at marketing, attracting lawsuits. I think that's going to increase with COVID-19 in the healthcare sector and otherwise. I mean, we've heard that one of the unfortunate consequences of COVID-19 is ongoing health problems in terms of coronary related issues, mental issues, dementia. There's going to be all kinds of things. Now, we have some healthcare immunity in several states, but I think there's going to be concentrated focus on these types of areas by the plaintiff's bar. But I think that attorney advertising, social media is another one. It's a new phenomenon in our for my generation. I didn't grow up with a phone in my hand 24/7. People get a lot of their information on social media. I think we've got a division in the United States like crazy. Anybody that watched the recent presidential debate will say that this is not good for the country, and it's not good for business and attitudes by jurors toward corporate America. And then I think you have demographic differences of opinion. I think historically there was much more of an attitude of self-responsibility. I think that shifted to an emphasis by the demographic generations Z and Y, and numbers in the alphabet I don't even understand, but where they have shifted that responsibility more to the corporation. The corporation is responsible to take care of its constituents, and we see that in the corporate governance area and many other areas. That it's not just about maximizing your profit for your shareholders. You got to take into account all of your stakeholders. And I think that's a shifting paradigm in thought about the role and responsibility of the corporation. So I see a number of phenomenon here that I believe are going to continue to support, enhance, advance the agenda of social inflation. And the plaintiffs' bar, those I refer to as the elite members of the plaintiffs' bar, are very, very intelligent, very smart. They see these trends, and they're going to pick their spots, I think, in where they believe they can maximize liability outcomes.
Okay. I mean, Chiara, on just picking up that, I mean, given that the tactics of the plaintiffs' bar have been particularly significant, is there any reason why the defense side, from your perspective, why isn't the defense side as active or as aggressive in pushing back against that, do you think?
I don't. So the first one will be the amount of funding for the plaintiffs' bar. I mean, as Damon said, there's a significant amount of money there, right? Both for the plaintiffs' attorneys themselves, as well as litigation funders who might be behind some of this. So there's the cost associated with it. And then when you take the insurers, I mean, we will certainly fight when we believe that there is no coverage, right? And we will settle when we believe there is, right? Now, of course, the amount can sometimes be debatable, but we certainly do fight back, I guess is the question you're asking. And we do everything we can. I mean, we do put together mock juries. We do engage specialist attorneys to help us determine whether or not it makes sense to litigate a claim. And then it comes down to, you know, how brutal can we be in court, you know, versus a plaintiff's attorney, because often we're dealing with individuals who have suffered some type of horrible bodily injury, right? And in that case, it can actually backfire on us if we are too aggressive or seen as coming out sort of on the attack. Now, I'm not an attorney and I'm not a claims professional, so that's just, you know, what I've learned from my colleagues. But I think the fact of the matter is the amount of money behind a number of these plaintiff's attorneys is something that insurance companies just can't compete with. So, I mean, the best way for us to deal with it is to, you know, underwrite the risks, restrict coverage as much as possible, or not restrict, sorry, but clarify the coverage as much as possible to leave gaps, or to eliminate the gaps so that there's nothing they can pick through there. Because really that's what they're coming after. They're coming after the insurance limit.
Actually, I want to they can do about it, but we're midway through probably now, so I wanted to give people an opportunity in the audience to kind of tap their expertise. And one of the questions that I often get asked is, well, how far is this just a US phenomenon? So we've got a couple of questions that hopefully Michael can flash up on the screen, which we want to take the temperature with the audience, which is how far will what we've seen in terms of social inflation eventually spread beyond the US? That's the first question. And the second question is, to the extent that it does, how far and in what lines will it show up? So it looks like we've got some responses already. I don't know if this is a complete sample, but it looks like there's, well, actually, no, it's not a complete sample. You've got the 4 and there's only 5 people who responded so far. But while the numbers are coming in, maybe I could ask Damon, I mean, how far do you think that the US phenomenon of social inflation, which gets a lot of the airtime, how far that might spread beyond the US shores?
Well, again, I would go back to the elite plaintiffs bar. They are not, U.S. centric necessarily. Europe has a very large market. Obviously, I think that there are some distinctions between the U.S. and Europe, but I think those distinctions might become less acute over time. For example, I don't live in Europe, but my understanding is there's far less quote unquote attorney advertising out there, lawyers actively soliciting business. I don't think there's the divisiveness in Europe politically that we have here in the US of the haves and the have-nots, and social media obviously is a big deal in Europe, but I also think you have less income inequality than we have in the US that's driving a lot of behaviors that people feel like they've got to get their pound of flesh out, so to speak, against corporate America. But again, that said, I know there are firms that are actively seeking out opportunities in Europe, particularly the UK right now, to try to test out these theories and get a greater amount of what we've been referring to as social inflation with outcomes and cases in Europe than we've seen in the past. So I think it's definitely going to be a topic to watch closely in Europe. And again, the litigation finance companies are not US centric alone as well. They are global. Investors are pouring money in from around the world. So I think I think an issue that is on the horizon that's going to become a bigger and bigger issue over time in terms of social inflation and its impact on the European insurance and reinsurance industries over the next 2 to 4 years is how I see it.
Yeah. And Chiara, are you actually seeing any of that showing up in some parts of the book, maybe particular lines already?
So if we think about what Damon said earlier in the session, where we see sort of an increase in claims trend, just general increase in cost associated with claims, yes, we do see that claims costs are increasing globally. That may or may not be influenced by social inflation. What we're not seeing is the huge court verdicts that we see in the US. And one important thing that I think Damon, or that I'd like to add to what Damon said, is Europe has universal health care, and one of the major drivers of some of the court verdicts in the US have been around cost of care, especially for individuals who need long-term care or suffered injuries that bring with them very expensive health care. Now, not all of that is always covered in the European countries. It varies by country depending on where you are. But generally speaking, there is a safety net there which helps to control some of those costs, right? So going aggressively after recuperating that may not be as fruitful as it is in the US. Then to answer your question, where are we seeing it? It's difficult to say, but we are seeing litigation funders pop up in different parts of the world. So we've seen them in South Africa, we've seen them in Southern Europe, so in Spain, Portugal, we've seen them in South America as well. Now on the GPPL side, to our knowledge, we have not been up against them yet on any claims from AGCNS. That doesn't mean it hasn't happened, because you don't always know where the funding is coming from. We are seeing it in the financial line space. It's very concerning. It's part of also the reason why rates are so high in that area. So there's definitely a focus for funders to go after D&O cases right now. So there's definitely an overall trend, but do I think that we're going to end up in a situation like the US and the rest of the world? No, I think that culturally it's just too different. But will there be some impact? Yes, potentially.
Okay, very interesting. I don't know if we got the results of the second question yet, but that might either confirm or reject what I see. So this is basically in what liability lines might social inflation show up most. If looks like we haven't got any responses to that, but maybe that's a technical issue. Maybe that will come in. Maybe people are still doing that. But actually, maybe what you've just said, Chiara, in terms of sort of some sort of doubts about whether there will be international contagion of some of the social inflation. Maybe that's a nice segue on to thinking about the pandemic and whether that has had any material change on both what's happening in the US, but also the potential broader implications. I guess most of the action is kind of very much geared around, certainly so far to date, is around a business interruption and on the property space. But I'm just wondering whether the pandemic, and Damon's kind of touched on this, could materially change the landscape, and in what ways might it do so? So maybe, Damon, given you've mentioned it already, maybe you could reiterate what your thoughts are about the pandemic and how that kind of flows through to social inflation, and then I'll come to Chiara.
Okay, well, I guess I'd preface it by saying that I don't think anybody really cares for the pandemic unless you really like to work from home. But in the got to throw some humor into this, right? In the context of litigation, as I said earlier, the courts really have been shut down for the most part. They're now reemerging with Zoom conference calls. There's been a few trials in person with social distancing and the like, but I think that the concern I have for the industry is that I think that all of the pre-existing causal factors that led to and have led to social inflation will only get worse as a result of the pandemic, given the catastrophic public health impact, as well as the catastrophic economic impact on millions and millions of people. So I think that there's social, income inequality, for example. I think there's a lot of the people that have been hard hit by this are in lower socioeconomic classes. And you've got outbreaks of COVID-19, for example, in underserved communities in the United States, the Bronx being one, and some other areas. So I think that I personally believe, it's my opinion, we don't have any tangible data now, but I think that the social inflation as a result of the pandemic, once the courts resume, I think we're going to see more of it, and perhaps more extreme outcomes with court cases and settlements and the like as a result of it. But right now, we just don't have any data because there's been very few court results. When you talk about business interruption, the batting average, as we would say in the US, is not 1,000. We've got a very, very small percentage of cases that have been decided on what we would call dispositive motions or early motions to determine whether the case should proceed. Most of those cases have been favorable to the industry, but not all of them. There's a long way to go. I think you said at the outset, I mean, there are thousands of cases related to COVID-19. So time will tell. But I think in all of the lines we're looking at here on the screen, I think social inflation is going to have as much or more of an impact once we resume normal activities vis-a-vis social inflation.
Yeah. Actually, I'm quite surprised at the spread here of this graph. I was anticipating, I guess I was a bit more in the Chiara camp where we see lots of it spreading overseas largely in the financial lines. But it seems a bit more broadly spread. People think it'll have a more contagious impact, maybe on the back of the pandemic. But Chiara, did you have any either reactions to what Damon said or even to do with the chart that's on screen?
Maybe just in terms of what Damon said, I believe that when the U.S. courts open, the factors that he mentioned earlier will have an impact on the desire to litigate in various areas. I do not think it will be driven from a liability perspective by COVID-19. I think it is an extremely difficult task ahead of a plaintiff's bar to prove where someone became ill, especially from a GTPL perspective, slightly easier on the workers' comp side. So I think that it might not be as fruitful for them to go after the GL policies as it would to go after the GL policies in other areas, right? So just sort of building on what he said, I do think that social inflation will continue. It will certainly be heightened, but not necessarily on COVID-19 related topics. So COVID will be more of an influencing factor in other cases.
Okay.
Interesting.
Yeah,
sorry, go ahead.
Oh, I was just going to say, why don't you finish? I had a few comments. I'll follow up once you're done.
Okay. And then just in terms of what we're seeing on the claims side, we have seen a number of claims filed. Most of them are closed because there's no coverage. And then certainly where we know there's been coverage, it actually hasn't been in the US, it's been in other areas. This is on the liability side. Those are still pending, and I mean, there is coverage, so we will pay them. But generally speaking, from a liability perspective in COVID-19, we don't see a lot. We see a very large potential for defense cost scenarios in the US as we look to defend against claims in those cases.
Damon.
Yeah, Darren, I was just going to add, I think one of the significant issues in these lines of business, general liability and so forth, medical malpractice, is going to be waivers and presumptions. In some states, there's a presumption that if someone had to go to work as an essential worker or work outside of the home, if they contracted COVID-19, there was a presumption that they contracted it on the job, and that the burden to prove that they did not contract it on the job would fall on the employer. And so we see that in some states. And I think that deals with the causation issue and basically shifts the burden of proof over to the employer and not the employee. I would say, secondly, there's been a lot of discussion and some movement on waivers, liability waivers. For the Europeans, we would refer to a waiver as insulating a business from liability, whether it's general liability or otherwise. And there's going to be a big issue down the road, I think, if you can get over the causation hurdle, whether there's a presumption or not of where you contracted it, I think waivers and the enforceability of waivers will be a big issue. And a lot of that, I think, is going to come down to whether it's in a federal court. And my opinion is you tend to get better judges. They're going to follow the letter of the law in general than state courts. In state courts, plaintiffs' lawyers are going to try to be strategic in where they bring the lawsuit. In state courts that are going to be more liberal in allowing what we lawyers in the U.S. would call junk science, expert witnesses that really can't cite to well-known and recognized periodicals, peer-reviewed articles and so forth to support their arguments, but try to get enough in to say that it's going to go to the jury about whether they contracted coronavirus in a particular shopping mall, on an airplane, on a cruise ship, and the like, and have a lawsuit for any personal injury they may have incurred. And the enforceability of those waivers is going to be a big deal because most of them carve out reckless or gross or grossly negligent or intentional conduct. And if you can get into the right court, that's in the eyes of the beholder, which would be the jury, to decide. Well, they practiced proper PPE. Their employees were wearing masks, but they didn't require the customers to wear masks, what have you. There could be all kinds of litigation. And again, I think smart lawyers will keep trying until they find that one case that's worth $5 million, where a restaurant or a business that's struggling to survive and they need the customers. And I've seen this in New York City. They want all the business they can get. And I've been to some of these where some of the patrons wearing masks and they're very careful, and others are standing in groups of people with no masks. So I think that remains to be seen of just, are those liability waivers going to be effective, whether it's healthcare workers or whether it's just business in general. Now, Ohio has introduced a very strong liability waiver. But it's really going to depend on the state, I think, in terms of where this whole process may go in terms of whether those waivers are enforceable or not.
Very interesting. I'm conscious of time, actually, Damon. So I was going to suggest that we need to kind of interject and ask if there are any audience questions.
Yes, so Darren, the debate was very stimulating. So we have 3 questions from the audience. The first one is, where do you see the main difference between social inflation and the risk of a change in liability? Then another one is related to which are the US industries where social inflation has the largest impact. And the third one is, if there are any thoughts to the potential for an increase in pre- and post-judgment interest award, given the legal environment you exposed.
Okay. I'm not sure I understand all of the questions, but maybe I can deflect some of the ones I don't. But let's start off with the easier one then, with basically where are we seeing? Are there any particular industries or sectors where we're seeing it most? And given that we've had this kind of US, non-US sort of, not so much tension, but sort of difference, maybe Damon, have you got any thoughts about where we're seeing it most in the US?
Yeah, well, again, it's so early, it's hard to predict, but I would say the high exposure areas are businesses that have a high exposure to customers that are on site, airports, shopping malls, restaurants, big, we call them big box stores like Walmart, Costco, Home Depot, where you have a high level of foot traffic, if you will, in and out of the buildings. And again, whether or to what extent those companies, Amazon is another one, they've been sued by their own workers claiming they didn't have proper personal protection equipment. Those large businesses, I think, have the greatest likelihood of claims coming in, that they did not take appropriate safety precautions. They may or may not have followed the public health advice. And one of the challenges there is that the public health advice varies at times from the federal instructions down to the state instructions, and it changes over time. There's been differences of opinion. As you may know, at the outset of the pandemic, our lead center of communicable disease, Mr. Fauci, was saying that masks were not effective. And it wasn't until later the federal government took the position that masks were effective. And now the president of the United States has contracted coronavirus, as well as the prime minister in the UK, the president of Brazil, many other prominent people in the world. So I think that is going to be the target of the plaintiffs' bar, are those large commercial operators, cruise ships, any kind of transportation industry, and the big box stores. And again, where you have the foot traffic. And I think the argument will be by the plaintiffs' bar, you didn't do enough. You didn't require these things. Another one is taking your temperature. I've had it many times where you get the heat temperature on your forehead in order to gain admittance. Other places I've gone into didn't require that. And again, I think it comes down to the statistical arguments they'll make, is that given the certain number of people in an establishment, I've heard this argument in a matter I'm handling. If you have a 2% infection rate and you have 30 people coming in and out of your premises, it's more likely than not that you have spread coronavirus. And those are the arguments they're going to make, is going back to Ciara's point, which I think is a good one, but I think they're going to resort more commonly to a statistical based approach, as opposed to we can specifically trace where you got it. If they can get the expert to come in and say there was more likely than not, a contraction at the premises, we want to get it to a jury. That's where the exposure lies, in my opinion.
Okay. And
maybe
the
I'll
first
just,
carry on, Ciara. Sorry.
Sorry, I was going to say, because I just saw the question on the screen, and I think in this case they were asking more generally on social inflation. So I agree with everything Damon said about where the coronavirus potential lawsuits will come, although I still think there are more workers' comp, but we'll talk about that at a later time. But this is really important to me, because I feel there's a sense that social inflation is something that only applies to large corporates. And I have to say, my experience is that that's not true. I think any company operating in the US, where we've seen this mainly, which somehow is implicated in a severe bodily injury, it can be impacted. So this can be a huge, large corporate, or it can be a small mom and pop shop. It doesn't matter. If someone is hurt and hurt severely, then there's a chance for social inflation, and there is a chance for a very large court settlement. So I just want to throw that out there, because too often I hear it's large corporate, it's large corporate. Yes, large corporates have large limits and are often sought after by plaintiffs' attorneys, but we see a number of mid-sized companies being pulled into lawsuits with jury verdicts being higher than we had anticipated. So I think that's basically the fundamental problem. It's difficult to say one specific industry is exposed more than others. Certainly anything that involves automobiles and trucking is one, but if you move past that, it's potential for any company operating in the United States to be brought into a lawsuit, which can end in a higher claims settlement than one would like.
Yeah.
So Darren, we have the last question from the audience. So do you agree that socioeconomic differences throughout US jurisdictions make it difficult to generalize US social inflation, education, income, cultural difference, for example? So do you agree or not?
Well, I'll ultimately probably going to defer to especially Damon, given where he's sitting. But I mean, one of the things that I think from our perspective, the study that we've been doing, we haven't really looked into that intra-US angle. But I have seen some interesting research, and it's an advert for Gen Re, actually, Jamin's former firm, where they put some interesting research out recently, which looks at sort of basically at county level and state level within the US. And to the extent that we've been talking about sort of inequality and the social inequality, income inequality being a factor that influences public sentiment and maybe jurors, they do find evidence that there's more evidence for that income inequality being correlated with the areas where they've had really large outside verdicts. So they draw the conclusion that actually some of that income inequality and the impact on jurors' sentiment and beliefs is actually greater where there's more income inequality. So some of those sort of nationwide factors may well be even more kind of prominent at the sort of interstate and county level. But Damon, do you have any thoughts on the intra-US story?
Yes, absolutely, and you're 100% correct in what you said. And any lawyer who receives an assignment to handle a case, the first thing you're going to do is look at where the case is set. Is it in state court? Is it in federal court? Who the judge is, and then try to find out what type of pattern of outcomes they've had, and whether and to what extent the judge is conservative and strict in allowing expert testimony in, or very liberal in allowing it in, and whether they're pro-plaintiff and pro-defendant. And, you know, in the US, we call them blue states, we call them red states, blue being Democrat controlled, Democratic governor and so forth. And a prominent example of that would be California or New York. And a red state would be a state that tends to be quite conservative. So you would start there, and then you would work down to the specific judge in question and evaluate your options. And it's one of the reasons why in the business interruption context, you've seen many insurance company defendants sued in state court. They take care, they pursue a mechanism we call removal, where if you meet certain criteria, you can remove your case or put your case into a federal court as opposed to a state court. And that happens very frequently because there's a general perception in the US that you're going to get a better outcome as a corporate defendant with a federal judge who is appointed for a life appointment, and they're not subject to elections, whereas many state court judges are subject to elections. And there's a lot of debate and discussion about fundraising and so forth that they have for some of them, and that some of them are in the pocket of the plaintiff's lawyers, and they'll do whatever's favorable to the plaintiff's lawyers. So that is a very, very significant issue of not what are the merits, but what's the reality of your case in terms of human nature of the judge in the courthouse. And if you go to a jury, are they going to look like you are wearing a black hat as an insurance company, and they're going to be very inclined to issue an award regardless of the merits of the case. So yes, there's a tremendous amount of analysis that goes in the front end, and it is very jurisdictionally based and judge based in terms of what you think might happen with your case. Again, almost irrespective of the merits, you know, you need to do that evaluation for your client and give them an assessment. Hey, this case should probably be settled. We should win the case with a good judge, but we don't have that, and we should be thinking about settlement. And that happens in every single case that comes across. Yeah,
I realize we're bumping up against the time limit now, but and I've got to do a summary in 30 seconds. But Chiara, am I cutting you off if I don't ask you to respond to anything?
No, that's fine. Okay.
So just in the spirit of time, and as Pier Paolo says, we can circle back to the questions and see if we can answer them in more detail to the online participants. But thank you very much to Chiara and Damon for what I think has been a really interesting discussion, some of which I think would kind of reinforce some of the thoughts I had, and some of them were new ones. I think it's one of the things I think the three things I took away. One is that what we've seen most recently is definitely there in terms of we've seen an acceleration in claims, but there's still this outstanding question about how far that's been a long run change the long run trend. I mean, COVID-19 may well kind of sort of answer some of that question, but I still think that there's this outstanding question about whether we're seeing a temporary deviation or a shift to a long run trend. The second one is very much, I think it's still true that lots of the debate is anchored around what goes on in the US. And I think that's still going to be a recurring theme. But I was interested where there was probably more certainly from the online poll, there was more evidence or interest in seeing some of this spread beyond the US. I was anticipating a little bit less contagion from the audience, but that seems like that's true, although it might well be more concentrated in particular lines. And the final thing is the pandemic, as I say, may well alter things completely, although I do sense that some of the different sort of regimes between the US and the elsewhere in the world could also have an impact on how widespread some of that impact will be of the pandemic. So again, that's probably a suck it and see at the moment, because a lot of it's still up in the air. But on that front, I ought to, again, thank my panelists, and thank the audience for listening in, and pass over to Marianne, who's going to take on the next panel.
So thank you, Darren, and thank you, Jara and Damon, for your useful and instructive discussion with many takeaways for the audience. And now let's move to the second panel on climate litigation risk. And Mariam Golnaraghi, who is a director, climate change and emerging environmental topics at the Geneva Association, and was previously chief international disaster risk reduction program at the World Meteorological Organization for 10 years. So she will chair this panel with other outstanding speakers. So please, Marianne, introduce your the other discussants and the topic.
Good morning, good afternoon. I hope everybody hears me well. It's a pleasure to be here together with two colleagues, Nigel Brooke, who is a partner as well as the head of climate risk practice at Clyde & Co, an international law firm, and also Jane Mandigo, senior expert and senior vice president in area of property and casualty business from Swiss Re America. So today we're going to take on the topic of climate litigation. If we can go to the next slide, please. We can start my slides. I will continue until the slides start working. Essentially, what we are going to do today, we will be addressing 4 key issues. First of all, we're going to give the audience a flavor of the landscape of climate litigation by jurisdictions, characteristics of cases, and drivers. We're going to look at types of cases that could have an impact on insurers and get deeply into what are some of the implications are for insurers that may go even far beyond underwriting liability. And also we will have a round with our panelists on their thoughts on what insurers can do. Next slide, please. Now, as some of you may know, climate litigation is starting to get momentum, and increasingly courtrooms are becoming a place for climate activists and others to use as a platform to inspire climate action. This goes far beyond requesting claims and for damages. And I think we are ready after here with our conference team to start a poll with the audience. There are 2 questions that we would like you to consider in this poll. First of all, is your company monitoring climate litigation cases? You're looking for yes or no. And do you think it is an emerging risk for the insurers. Also, the answers are, in your thoughts, yes or no. Let's wait a moment for that. So we are monitoring the responses to the first questions. This is very good to see that, in fact, we are seeing a prominent response towards yes, given that we will be looking at this area as a serious emerging risk for the industry. And if maybe we can move to the next. Do you think it is an emerging risk for insurers? My assumption would be, given that you are also, the answer was quite positive in terms of the first question, it will be the same for the second question. Maybe we can now move forward. I think what we see here is a very prominent result in terms of yes to both answers. If you can go back to the slides, please, where I want to show some stats before we move to the discussion with the panelists. Until the slides come, I just wanted to maybe make one last point. If you can please move to the next slide. Thank you, this is perfect. So I just wanted to give you some idea about the distribution of climate litigation cases by jurisdictions. This is based on documented cases from two databases available through Columbia University and London School of Economics. Essentially, we can divide the evolution of climate litigation risk in three phases. Wave one before 2007, this was predominantly a situation in US and Australia. By wave two, which is between 2007 and 2015, this expanded to UK and Europe. And finally, wave three, which is since 2015, it has ramped up in other jurisdictions. I have also indicated some of the numbers of the total of 1,660 cases recorded until September of 2020. We will see what the distribution has been, with significant prominence in US, but definitely growing in other jurisdictions. So with that, I'd like to move to our panelists and first invite Nigel Brooke to give a short 4-minute brief statement around some of the major developments around characteristics of climate litigation landscape, how it's evolving, and in the very many ways that it could impact the insurance industry. Nigel, over to you. Thank you.
Thanks, Mariam. Next slide, please. So we're seeing one of the drivers and amplifiers of climate litigation. Physical risk, as we've heard earlier, is becoming more and more obvious. Perhaps the most prominent at the moment are the wildfires on the west coast of the USA, which are setting new records. We just had one that's burned 1 million acres by itself. Just astonishing things going on there. And this is a harbinger of things to come. So it's becoming harder and harder to ignore, and that is a driver. Transition risk as well is making itself felt. We've just seen Exxon drop out of the Dow Jones. But there's lots of other indicators that the transition is already underway, with some of this just a flywheel of technological developments, price drops and so on, but then you could also have increasing climate commitments by governments. COP26 talks were due to take place in Glasgow next month. They've been postponed by a year. Governments around the world should be upping their commitments. China has set the pace recently by declaring it will go net zero carbon by 2060. And that might actually make other governments more ambitious as well and set the pace, and that could greatly accelerate the transition. With that increasing pace of the transition, you see increasing risk and turbulence as well, which can give rise to litigation. There's also activism that has been enormously ramped up. We're seeing it most obviously in Europe, and these activists are now going to the courtroom. One of the most active players in this field is Client Earth. I'll come back to them. Standards of care are moving on, particularly in common law countries. They adapt depending on circumstances, and as the scale of the climate crisis becomes more and more obvious, as we get to know more and more at a granular level about climate change and its drivers, and at a local level, so the standards of care will evolve. Then the kinds of cases, most of the cases still are against governments. They're usually about trying to force governments to move faster, either be more ambitious on the cuts to emissions or their transition to lower carbon economy, or in a few cases, pushing them into taking steps to address physical risk as well, which is affecting their citizens. But we are seeing a fast-growing batch of cases against corporations as well. Against corporations, some of the claims are about money. The most prominent of those are claims brought by municipalities and states in the USA, which we've seen another 3 or 4 filed in the last 4 weeks against the oil majors, where they're suing for billions of dollars, saying the climate change caused by oil and gas consumption is forcing them to incur massive expense or to lose their tax bases. But also we're seeing strategic cases brought by activists and others trying to accelerate the transition. Some of these cases aren't headlines about climate change, but they are actually, for example, using corporate law or whatever, but they have a climate change motivation as well. The activists and others are exchanging precedents. The lawyers, it's not just the activists, it's also the judges who are exchanging best practice, environmental lawyers, so that we're seeing evolving rulings from judges and then adopting rulings from other countries as well. And also climate change attribution science. This is a fast developing field where scientists are getting more and more confident they can identify the fingerprint of climate change on, for example, a specific windstorm or a specific heat wave. Next page. So then also looking quickly at the impact on insurers, Jane will have a lot more to say on this, but 4 categories. Liability underwriting, obviously the most obvious category, where you could be issuing a general liability policy to an oil or gas or coal company, but also you could have professional indemnity, for example, against architects and engineers who failed to design with climate change in mind, or it could be directors and officers claims, for example, for misreporting on climate exposure. You could see also climate litigation shifting, accelerating the transition and therefore affecting books of business. So, for example, an energy book in 10 years' time will look very different, very likely, from what it is today. Who are the major players that you're insuring? Investment side can get hit by this. There's the shifts in investments, even bonds, for example, could be hit by this. Corporate and sovereign bonds, for example, Australia, South Africa, countries which depend very heavily on coal exports, could see drops in the value of their bonds if the transition accelerates. And then also governance issues. This perhaps is the furthest away, but potentially in the future, insurers could face regulatory sanctions for failing to address liability risk. This will become a feature, we think, not just in the UK, but in other countries, of your regulatory returns, your exposure to climate liability, and potentially insurers themselves could become a litigation target, but perhaps that is some way off.
Excellent, Nigel. Thank you very much. And I think the point that it's being stressed here that potential risk to insurers could go far beyond what traditionally has been thought about as liability underwriting only. And we will get into some of the details. Let me now turn to Jane. Jane, a pleasure having you here. I think you're going to come with a short brief, taking a deeper dive into what does climate litigation mean for insurance business model, particularly focusing on lines of business. Over to you. Thank you.
Thanks. I think I have a companion slide if it's available. And I wanted to offer this quote, which will frame our discussion, which is that climate change poses an unquantified risk for the insurance and reinsurance industry. So with that as the backdrop, if you'll move to the next slide, I agree with Nigel that the classic discussions about climate change center on these topics of physical risk and transition risk and liability risk. And for insurers, these are all quite relevant, but what we do is we will try to group all of them into an analysis of exposure by product line. And so we'll look at a line of business and think about those questions. What's the physical risk? What are the transition issues? What can we anticipate in terms of what will be the loss, or what will be the allegations of liability? And then how might that translate into insurance exposure? And an example of this, you can see on the slide, 3 key categories that we're thinking about would be property, casualty, and professional lines. And the one most people think of first is property risk. And there is more advanced data on the impact of climate change for property risk, and we pay attention to the signals for how we're going to assess that risk. And for property risk, one of the signals has been this increase in secondary perils. And in fact, last year, 60% of our insured property losses were from secondary perils. And secondary perils, if you don't know what those are, they follow primary perils like a hurricane or an earthquake, but secondary perils could be things like torrential rains or floods that follow the hurricane, or a fire after an earthquake. And here we are seeing higher frequency, but admittedly, we just don't have sophisticated tools to build extremely accurate models. And one of the things that this reminds us about is the fact that the insurance industry has been so dependent on using past experience to predict future loss. And with climate change, you can't do that. So you have this reduced level of confidence in the accuracy of any prediction. And the reason for this is you have, I would say, staggering variables, including the causation issue and the impact issue and timing issues, whether you're talking about in 1 year or in a decade or even 100 years from now. And in addition to that, we have all of these unknowns with respect to the efficacy, if you will, of decarbonization efforts. And all of these things are oscillating as inputs into any particular model. I'll move over to casualty for a second, which is there's even less data here with respect to how we can try to estimate climate change exposures. And this is what starts to make scenario modeling an important tool. And again, little historical data that's going to give us confidence in some sort of empirical modeling. Most of the think tanks out there are evaluating scenarios of new types of loss, or they're thinking about known loss and how that might shift or evolve. And I can talk some more about some of those issues in the main discussion. But then we also have areas like professional lines where you don't exactly have a direct climate change loss, but what you do have, what you see are these emerging concepts of new duties and or new responsibilities. And these can make lines of business like D&O a target. It's already been a target for what we would call climate related litigation. So for the insurance marketplace, we see these ideas of physical and transition and liability risk, but we will naturally group those together when we think about exposures by line of business. So thank you.
Excellent. Thank you very much. I think you both have raised a number of issues that we need to dig in deeper. One of those, I want to highlight two issues here. First of all, I think, Jane, you raised the importance of different types of claims, and in Nigel's presentation, we looked at, strategic versus damage, also classification by when climate change is central or not. Let me first ask you each to make a bit more detailed remarks, starting with Nigel, as to, in terms of evolution of types of claims and categorization of that, what are some of the issues, in your opinion, insurers need to keep in mind moving from more traditional thinking to how the field is evolving, particularly with underpinning causes of these cases moving ahead?
Okay, so if we start with the most obvious, the highest profile cases, the ones in the USA against all majors, they're adopting product liability, nuisance, and also in some cases false advertising cases. And we'll come back perhaps later on to the parallels with other product liability litigation. We may see more of that. We already are seeing similar theories brought in an activist case in Germany against the RWE, the utility. So I think that those are going to be drivers. And of course, if any of these cases gets any traction, they're years away from trial, but if any of them get some traction, then we can expect to see this type of liability or claim explode, because this is what's so different about climate change from any other litigation that's gone before it, that climate change affects everybody. So anyone who's suffered property damage or personal injury is potentially a claimant. And they can claim against anybody who's responsible for emissions anywhere in the world. They don't have to prove any local effect. So the one in Germany is a good case in point. It's being brought nominally by a Peruvian farmer against a German utility, just to really ram home this point that this is a global issue. I think we should keep a close eye on activist cases. At the moment, they're primarily looking to bring about change. So they want to see changes in behaviour rather than to claim damages. But some of the arguments they're adopting, entirely novel arguments like human rights, for example. So we've actually, in the last 18 months, we've seen the first human rights-based cases against corporations, one in France against Total and one in the Netherlands against Royal Dutch Shell. And again, those are at the moment, the relief they're seeking is a change in their behavior, an accelerated transition. But very easily, those could be transformed into damages claims. So this is a fast evolving field. It's that the kinds of claim don't necessarily fit the traditional mold.
Thank you very much for that. And Jane, in your presentation, before we move on to some other questions, I want to highlight a very important point that you raised, the fact that the traditional approach to using past data to reflect on potential exposure for the future may not be what works here. And as Nigel has said, the fast evolving climate litigation cases prove to that, but you've talked about scenario analysis. And I want you to dig a little bit deeper as to what you're alluding to and what does that mean in terms of moving ahead and the kind of capacities insurers need to have to develop these scenarios.
Sure, and I think this is a really fascinating topic. It's one that we've been working on internally, and I can share some examples of exposures with respect to casualty risks. People kind of know what they think of when they think of property risks, but I'd like to highlight some of the things that we're thinking about in terms of the scenario modeling. And the first one, I guess, is infrastructure risk. And if you're not already aware of what's considered kind of the decaying infrastructure, at least in the US, we got a grade of D, which is one grade above failing from the American Society of Engineers, and that was for the status of our US infrastructures. And something like climate change is going to make that worse. If you think about airports, for example, we know there are at least 80 airports worldwide that could be underwater if sea levels rise up to 3 feet. Bridges are another example, and bridges are subject to thermal stress. At least a quarter of steel girder bridges could at least risk falling by the year 2040. So we're thinking about these kinds of scenarios. Transportation is another area. The shipping industry, think about rising sea levels that could close shipping channels. And another great example is, I don't know if a lot of people have heard about NATEC risks, but this is something that's already had a casualty impact. NATEC is NATECH, and it's the name for when a natural event such as a flood or a heat wave triggers some sort of technological malfunction leading to the release of a hazardous material. And we've already seen this. Hurricane Katrina, we saw the Murphy oil storage tanks and they floated off their foundations, and there were these liability cases filed based on the asserted foreseeability of this kind of event, and Murphy Oil ended up paying hundreds of millions of dollars for that. And another example is there are almost 1,000 Superfund sites that are at risk of, again, toxic releases if we have a weather event or rising sea levels. So we're thinking about those scenarios. I'll give a couple of other examples. Agriculture. There's a thought that with climate change, pests may have longer lifespans. This could increase the use of pesticides, or it could constrict growing seasons, whether it's hotter weather or cooler weather. This could result in an increased use of fertilizer and cause allegations of personal injury. As we know from the Monsanto litigation, we've had some nuclear verdicts come down from that. Or you could see increased claims based on something like pesticide contamination due to flooding. And then I guess the last one that I would mention in terms of thinking about scenarios, and I think this is one of the hardest ones, is supply chain issues. And supply chain issues are very difficult to map, but I'll give a couple of examples there, which are where you have storage of component parts, for example. If those are subject to extreme conditions, you could have increased product defect claims, or if there is a weather event that makes those component parts simply unavailable, you could have increased casualty claims. And I know some of these seem maybe far-fetched or minor right now, or somewhat remote and gradual, and you know, should we really pay attention to those now? But the smarter route is to think about these and invest in the scenario modeling. So
excellent, thank you so much. And that is clearly an area that I think industry is taking up upon. We can discuss that in a bit more detail later, but we have limited time, so maybe I can just ask one more set of questions, and then we can turn to the audience to see if there are any questions. Otherwise, we can continue. I have a list of 20 questions here that I could be asking you, but I want to go back. In the previous panel, we discussed COVID-19 and implications for social inflation. I want to come back on, where do you think the implications of COVID-19 crisis and related responses may have direct or indirect impacts on climate litigation, or would it, in your opinion? Maybe we can start with Nigel.
I think it could, indirectly at least. COVID has, first of all, opened people's eyes to pollution in the most general sense, air flights and so on. But also, what we're likely to see in the next few months is big announcements of massive spending programs around the world to try to kickstart economies. Certainly in Europe, it looks like that's going to have a very green tinge to it. The EU has already declared that. The UK has now this week declared that as well, and so has South Korea. So if we do see that, that's going to give an enormous acceleration to the transition, and it could then have the effect of keeping oil and gas prices down and keeping them down long term. This could strand more assets faster. So we could see, we're already seeing it, but we see more of this, of coal and oil assets being retired. Some companies going to the wall because there is very high leverage in that area. And that in itself, that's when we see losses, and we see perhaps investment portfolios dropping in value. That has historically tended to lead to lawsuits.
Excellent. Jane, any comments from your side?
Yeah, I have an interesting observation, which is, I think when COVID first arrived, there was a lot of attention suggesting that, oh, you know, climate change is going to get pushed aside. There were concerns, as Nigel said, about, you know, delayed summits or delayed regulations. But ironically, the fact that there was so much press about whether climate change was going to be set aside, I think it raised it as a point of awareness. I think there's also been this fallacy that, oh, you know, COVID-19 is proving that, you know, we can just solve climate change immediately. And while emissions are down, the truth is that CO concentrations are still increasing. So, you know, let's not get too excited about that. We saw that we could do it, and that maybe provided some reality to the realistic nature of some carbon reduction commitments. And I'll just add one other thing, that from the insurance perspective, one of the impacts of COVID-19 has been, I would say, an acute awakening to the importance of being very clear about coverage intentions and how those are set forth in either terms or conditions or exclusions, and that those issues need to be taken up. Again, with thinking about scenario modeling, we should have done that with pandemic issues before climate change losses are more upon us, and to make clear that if we want to cover that, that intention is clear. If there is an interest in excluding certain nuances of climate related exposure, we ought to be addressing those now as an insurance industry.
Yeah. Just one quick point.
Please
just
go
on
ahead.
the scenarios. Just this morning, I think maybe yesterday, IOPA has published a consultation paper on scenarios, which they're pressing regulators across the EU to adopt. So it's very much on trend.
Absolutely, and even if I can add to that, and I will make it in my summary, obviously there is significant development with regulators, even in the United States, particularly on the financial sector side. Some developments are taking place that could impact insurance on the investment side. But this is an area that's evolving, and the latest is that, you know, Bank of England, PRA, has even convened a working group on climate litigation. So the discussions are going far beyond how the industry is being affected by physical and transition risk and scenarios that are being developed around that, but also a direct look at climate litigation. Let me I love to draw some similarities and differences, as you see, between climate litigation cases and some of the other past major developments in litigation that have impacted the industry. For example, asbestos or tobacco. What do you see as core similarities or differences? And in what ways climate litigation cases may be, in fact, different, and what insurers need to take into consideration? Maybe we go with Jane first. Jane, over to you.
Sure, and I'll just start with opioids. It kind of followed the tobacco pattern, although opioids is far more complex than the tobacco litigation. And the thing that I'll point out is that with the opioid litigation, it focused primarily on a liability theory of public nuisance and then a remedy of abatement. And for the insurance industry, we have viewed this as an incredibly unfortunate expansion of traditional public nuisance concepts, and opioid litigation hasn't proceeded on individual claims because that was just exceedingly tedious and unlikely to prove against so many different defendants. So public nuisance is just easier. The courts are increasingly more amenable to applying it in a casualty or tort, non-property tort context. So what you have is this a friendlier approach to general harm and general damage model, and the plaintiff's bar is of course going to follow the path of least resistance. Another analogy that I will draw is in the Monsanto Roundup litigation. For 40 years, we didn't see litigation with respect to Monsanto Roundup, and then expert testimony was finally allowed in, and you saw these massive verdicts come in and then an avalanche of lawsuits. And I think that same trend is analogous in climate litigation, with the increasing sophistication of attribution science, and that is now creating this opportunity to start articulating discrete liability positions against the carbon majors and others.
Thank you. Nigel, any thoughts on your side?
Yes, so I echo everything Jane said about that. The opioids is perhaps the most recent example, but these cases all built on each other. I think the asbestos was the first main foundations here, particularly where you weren't quite sure which shipyard or whatever had exposed you to the fatal fiber. So they said, right, you're all liable. Same with the oil majors. They've developed this collective theory of liability in the MTPE litigation some years ago, and some of which are still going on, where they've said we don't know precisely whose gasoline it was that got into this well, so we'll just attribute it based on your market share for this area. Shell, you're paying 10%, Exxon, you're paying 20%, and so on. But then also perhaps the biggest parallels with tobacco, where that litigation really took off, where they had documents from whistleblowers and so on, which showed the tobacco companies had been deliberately misleading the public for years, and had known what the science said. Their own scientists were telling them, but it nonetheless ploughed on and lobbied against regulations on. Look at the pleadings by the municipalities against the oil majors, and it's exactly the same playbook. In fact, it's a lot of the same plaintiff law firms. They've built up this theory of liability, and they've just ramped it still further up. But there is a major distinction. Opioids, asbestos, the tobacco, these are all the people who suffered were the people who ingested the product. So it's very localized. If you weren't exposed to that product, you didn't suffer. Obviously, climate change is different. The claim here is for the effects on the world's climate. Maybe localized effects of the world's climate, but it is that impact that's being sued for. As far as I'm aware, there's never been a litigation that ambitious before. And you've already had a couple of cases struck out for that very reason, that they're just, the judge, for example, in the San Francisco case 2 years ago, essentially said, this is above my pay grade. This is a matter for governments to sort out rather than the courts. But if you get a judge who takes a different view, and some of these cases are going on now, the Rhode Island case is going to discovery, who knows?
Excellent. And Pier Paolo, if you want to come in any time, if there are any questions from the audience, please let me know, because I know you're checking what's coming through the chat, but I keep continuing to have this conversation. And now, Nigel, in your presentation, you identified 4 ways that an insurance company could get affected. One would be through liability underwriting, second one through underwriting other lines of business, third one is through investments, and then last one is through the governance of the companies could get impacted. This actually is a question for both of you. What I would love to know is, first of all, has there been any climate litigation cases directly against an insurer? Nigel, maybe you can respond to that. And then the second one is, if you can take these 4 areas and give us some examples of how these impacts are or could potentially be materializing along those 4 lines. So to start, has there been a climate litigation case directly against an insurer?
I'm not aware of any directly against insurers. You can conceive of how they could arise. The most likely, I think, most plausible at this stage would be an activist case against insurers for their role in being perceived as supporting the oil and gas industry. There's been a high-profile campaign that's been going on now for 3 years to try to force insurers to stop underwriting coal and divest from coal. It used to be called Unfriend Coal. It's now changed its name. It's broadening its range into fossil fuels generally. But you could well see how they could take a step further and try to use the courts to actually force that on them. This insurers, of course, as the regulators start to get interested in this whole area, that again could potentially give rise to liability in the future, but some way down the track, I think.
Excellent, thank you. Jane, anything from you? And maybe you can also, both of you, give us a little bit more details along those 4 ways that insurers can get impacted, with like maybe 1 or 2 minutes, because we are already running out of time and we need to wrap up soon.
Sure,
Jane,
and I agree with Nigel. We really haven't seen specific cases against insurance companies. I heard reference to San Francisco attempting to file something, but you know, I could not find what happened there. So I agree with Nigel. It's not much yet in terms of impacts on insurers and what they're doing. You know, I think this is receiving quite a bit of attention within insurers, and certainly insurers based on public pressure and their own initiatives are making significant corporate commitments, and they're also thinking about how to offer insurance for carbon reduction technologies or new products. You see insurers more and more partnering with tech industries to try to build better modeling, and that's a fascinating area and very sophisticated. And then I would say, you know, in terms of underwriting risk and helping insureds with risk awareness, with trucking or product liability in the past, we could very much see what the risk was going to be, but with climate change, you're often 1 or 2 or 3 steps removed in terms of thinking, well, what could possibly happen, and trying to evaluate that. But what I would relate that back to is I remember probably a decade ago when cyber started to hit the marketplace and nobody knew what was going to happen, and you could either kind of get on the bandwagon and get your hands dirty or stay out of it. What a lot of carriers did was just sit down and start thinking about scenarios and what would happen if this occurred, and our cedents and our business partners were sending questions. Would this be covered? Would this not be covered? And it led to a lot of discussion, whether it was internal or national or even global discussions about anticipating these kinds of scenarios. So I think those are some of the nuances of how insurers are affected.
Excellent. Thank you so much. So I think we are really running out of time. If each of you have a 1-minute closing remark on what you suggest insurers to do moving forward, realizing from the polls that majority are following up on this field and do believe that it's an emerging risk for the industry. If you can give a 1-minute summary of where you think insurers should go from here.
Shall I kick off? I think develop a better understanding, more sophisticated understanding of the whole variety of forms that climate litigation could take and the various targets that it could involve. At the moment, the most obvious targets, and I think probably the most prominent as well, would be in the carbon intensive sectors, but I think we will increasingly see litigation in left field litigation against investment advisors and so on. So just scenarios would be a very good way of doing this. Assess where this risk could come up and which parts of the book, and looking deeper than the first or second level. And then beyond that, starting a dialogue with some of the clients, with the customers. The customers themselves, we've spoken to a lot of them, they themselves are thinking hard, the ones in the most exposed sectors. And there may be ways that they can be persuaded or helped to minimize their own risk of being sued. Even those in carbon intensive sectors, if they are starting to make the transition, there may be things they can do to reduce or minimize their own risk of being sued, and that's a dialogue that insurers can join them in.
Excellent. Thank you, Jane. Any last minute thoughts?
Completely agree with Nigel. You know, it's a tough topic to model. We have to make serious commitments and investments in scenario thinking. It's a global issue for not just the insurance industry, but every industry. And I did come across a comment that I wanted to share from someone who had said that COVID-19 has been a harsh reminder that the facts of nature won't go away. And I think we have to apply that perspective and stay committed to addressing climate change. And this is going to happen for years to come. It's a long-term project.
Excellent. Thank you so much. And with those remarks, I want to just make a statement that Geneva Association is taking 3 major studies around the scenario analysis, looking at climate litigation risk, and really engaging, hopefully, in the future with regulators through working with the industry on shaping some of the upcoming dialogue. But please tune into the work of the GA in the future months, as there will be a lot more clarity on this. And with that, I really want to thank Jane and Nigel. This was a very exciting conversation. And with that, I will hand over to Pier Paolo to introduce the next panel and the chairman. Thank you very much to all of you. Thank you.
Oh, thanks, Mariam, Nigel, and Jane for participating in this conference and for your useful and instructive, comments. You have anticipated the questions from the audience, but now let's move to the third session, which is the session on artificial intelligence and liability regimes. And Florian Löbli, who is head New Economy, Autonomy and Technology Underwriting Vertical and a hub underwriting international casualty at AXA XL, with a past leading position at XL, Kathleen will chair this session. So please, Florian, introduce the outstanding discussant in your panel together with the topic.
Thank you very much, Pier Paolo, and welcome everyone to this virtual session and discussion around artificial intelligence and liability regimes. You might now wonder why this topic is going to be discussed again after already being on the agenda during last year's conference. But our aim today is to host this very open discussion on this very important topic, given that this year has seen significant developments in the AI regulatory proposal environment, most dominantly, and we will come to that in a minute, at the EU level. And this may definitely shape the entire future of the AI liability regimes. So the scope of today's discussion is going to be a quick intro at the beginning through me, quick also intro into the topic, then followed by an open discussion with my dear panelist colleagues, which I will introduce in a minute, then followed by a Q&A, as those that have joined the other 2 sessions already know, where we will answer all the questions you might have during the session at the end. So you can just enter your questions into the dialog boxes and we will catch them up at the end. So as Pier Paolo kindly already introduced, my name is Florian Löbli and I'm heading the so-called NEAT underwriting vertical, which is actually stands for New Economy, Autonomy and Technology. And what we're actually doing there is focusing on the broad variety of emerging business models in the space of these industries and in the area of technology-driven business models, such things like crypto, as well as artificial intelligence, which then is also the reason why this is very interesting for me and my team, the entire topic, as on a daily business basis, we more and more have discussions with our clients regarding the entire liability aspects of AI and its impact to the risk management. This is mainly focusing on topics like product liability and, as an example, non-material damage discussions. It is about clarification on allocation of responsibility. And last but not least, it's also a very simple question for that from their point of view. It's what's the actual rules around compensation when it comes to victims. And there's a lot going on, and that's why I'm very happy that we have the chance today to try to bring some more light into the dark around these topics. supported by two people who are actually monitoring and actively engaging with the regulatory developments and discussions in the EU as well as in the US, and represent there the insurance industry voice in these matters. This is on one hand Fabian Zwagemakers, who is a policy advisor in public affairs for Insurance Europe. Fabian, I hope I pronounce your name the right way, and if not, please shout. And on the other hand, from the US perspective, we're glad to have Angela Gleason from the American Property Casualty Insurance Association with us today. Angela is also a Senior Director, Cybersecurity and Counsel of the APCIA Cyber Innovation and IT Committee. So hello to you both, and thanks again very much for your time today. But before we go into an in-depth discussion, I would like to provide you with a little background around the issue and to set a little bit the frame of today's session. So when we talk about AI, right, there are multiple interpretations and definitions around it, but while there are a lot of technical definitions, we would go AXA internally, we would go with the OECD definition that defines AI systems as a machine-based system that can, for a given set of human-defined objectives, and I think that's the core then later for our discussion, it's humanly defined objectives, make predictions, recommendations, or decisions influencing real or virtual environment. And the question now is, what is it about AI now specifically that has regulators and legislators looking at to reform the current liability regimes, right? And on one hand, on the European side, end of last year, when I remember correctly, there has been a European Commission expert group that concluded that actually the liability regime currently in force for EU member states provide basic protection of victims whose damage was caused by operations of these new technologies. But at the same time, they also acknowledge and recognize that there are specific characteristics of AI applications, such as complexity, modification through updates, self-learning, as well as certain limited predictability environments that makes it very difficult for victims to seek compensation. That was one learning out of this group. The second acknowledgement was that actually the allocation of liability, there is a certain element that could be unfair and inefficient within the entire AI environment. And so this group recommended that there should be an adjustment to EU regional and national liability regimes. So the European Union, the European Commission and Parliament have then put forward a risk-based AI liability regime proposal to address these issues and provide certain additional legal certainty. Okay, and for us in the insurance industry, this then might have significant effects on availability of insurance, and on the other hand, on the technical side, also for AI innovation. Right, as always, the regulatory framework is heavily influencing both sides. So that's the EU side. So from a US perspective, while the European Union looks to be more the first mover in creating a specific regime around it, in the US, the preference is to keep an innovation-led and light-touch regulatory approach. So there are different legislative and regulatory initiatives in relation to AI ongoing, ranging from bills and driverless cars to voluntary AI principles for explainable and ethical AI. But clearly, these present two vastly different regional approaches right? When you look at what the EU is developing, how the US is approaching it in terms of AI liability environments. So the idea of this session now is really that we unpick these two approaches in a first stage to fully understand the background of it, then start to dig into the liability implications of it, and then actually explore whether AI really warrants a new legal approach, and potentially how we could bring them even together to get a global harmonized approach, if this is required or not. So that side, I'd like to turn now back to the actual stars of today's session with Fabian and Angela, and go through some of these topics. And if it's okay for you, I would directly dig into the first topic and the first discussion point, which is around the background of these two approaches. And maybe Fabian, as a start, we heard now a lot about the latest development in the EU, and it seems that there is clearly a try to lead in developing the legal liability regime around artificial intelligence. So could you please briefly explain to the audience these latest developments on European Commission as well as Parliament level, and could you give maybe some examples of the potential implications these proposals may have on the insurance industry?
Yes, for sure. So before I get into that, I would like to say as a starting point that in the experience of European insurers, the existing liability framework at EU level, so that is the European Product Liability Directive, in conjunction with national tort laws, actually works well in practice for artificial intelligence. And when the Commission reviewed, which it does every 5 years, the Product Liability Directive in 2018, they actually confirmed that this was the case. So when we talk about recent developments, we are now expecting the Commission to put forward a legislative proposal on artificial intelligence, which touches upon liability as well in the first few months of 2021. Now we have an idea of what the Commission's thinking is about with regard to the liability aspects, because they outline some options and ideas in a white paper on AI and a report on the safety and liability implications of AI, the Internet of Things and robotics that were presented in February of this year. So there are a few elements of particular interest, which I will briefly touch upon now, and I'll explain what the implications might be for the industry. So in the first place, the Commission is considering to clarify the scope and some of the definitions of the EU Product Liability Directive. And the purpose would then be to reflect the complexity of emerging technologies and artificial intelligence, and to make sure that victims actually will be able to receive appropriate compensation with these new technologies based on harm that these technologies could cause. So this is not necessarily something we would oppose to as Insurance Europe. In fact, it might be useful to have some additional non-legislative guidance on the interpretation of some of the concepts, and to make sure that there aren't any gray zones and that there's not any legal uncertainty. Of course, this guidance will have to pertain to clearly perceived gaps and not just randomly all over the place. In the second place, the Commission is looking at the possibility of reversing the burden of proof, which is currently mostly on the consumer in the EU framework. This is something we would consider a major change to the existing liability framework, and therefore something we believe could harm the now very well balanced system of, on the one hand, consumer protection, and on the other hand, the opportunity for innovators to bring new solutions to the market. And as insurance products are priced on the basis of this balance, that could actually translate into insurability challenges. Then last but definitely not least, the Commission is exploring the extent to which strict liability could be paired with compulsory insurance. And this is something we would definitely seek to avoid, as we believe that compulsory insurance would not work for the case of AI. It's something that works perhaps when risks are sufficiently similar and when certain pre-market conditions are met, such as the availability of data, of appetite for competition amongst insurers, and of course also enough reinsurance capacity, and this is currently not the case for AI. Then that's the Parliament. Oh, sorry, that's the Commission. So moving on to the Parliament, last week the European Parliament's Legal Committee adopted a report on a civil liability framework of AI, and we haven't seen this final report yet, and actually it's still to be voted on by the full European Parliament in the third week of October. This is a formality, but we know that the Commission is closely looking at what the Parliament is doing, so it will be important. We know that the Parliament will call on the Commission to incorporate in the scope of a future regulation immaterial harm that could result or that results in verifiable economic loss. And we are now working with our members on a technical legal analysis to assess the extent to which this is possible and the extent to which this could actually be very problematic. I understand that insurers in Europe at the moment provide cover for loss that is consequential, and they don't provide cover per se for verifiable economic loss. If they do provide cover, it would be for pure financial loss, if they do that at all, and that would be for and that's non-consequential. And then secondly, we understand that the Parliament will call on the Commission to present a list of AI applications in view of determining what are high-risk applications, and then we expect the Commission might propose compulsory insurance for those high-risk applications. So it will be our mission, at the very least, to make sure that that list remains as short as possible, and that any guidance from the Commission would be as clear and as transparent as possible as well. I'll stop it there for now. Okay, thank you very much for this very holistic overview. Angela, when you hear now even that there is even a push for compulsory insurance approaches around a very flexible environment like the AI, this definitely looks like a big contrast to what is currently happening in the US. So could you maybe walk us a little bit through some of the US related AI perspectives, the initiatives around it, and how this might impact the entire insurance industry from a liability perspective? And maybe if you could also have a differentiate between what happens on federal level as well as on state level, to have a little bit the differences, the potential differences there as well.
Sure. So, yes, we have a very different landscape here in the US that we are dealing with. Our legislators and regulators are more focused on the front end rather than something went wrong, how do we penalize? So I think right now, for example, I'm just going to go through a few of the efforts that are underway. Recently, on a general industry, national level, regardless of industry, the Office of Management and Budget, which sits in our executive branch, they developed guidance for federal regulatory agencies that may be seeking to regulate AI applications. And so the guidance is still in draft form, but it encourages federal agencies to utilize an approach that fosters innovation, growth, and engenders trust while protecting consumers. So there's a real strong push for these regulatory agencies to understand how the laws and regulations already apply to AI, and to use those regimes first. And that's consistent even on the liability side, where they recognize that there's already a broad legal environment that applies to AI. So if there is a lack of clarity and you feel you need to regulate, then you should look at a balanced approach for identifying what that accountability regime looks like. And to bring that down a level for one specific federal regulatory agency is the FTC, the Federal Trade Commission. And they recently had a blog earlier this year that talked about AI and its sophistication, and it's really just, they label it as a new sophisticated tool, but not anything else about it is new. Automated decision making has been around for forever, and industry has been using data forever. And so the FTC again gives you that approach to say, we have long experience with algorithms, we have a long experience with data, and so if you're looking for how to interact in this space, look at what we've done in those areas. So really emphasizing transparency, explainability, fairness, empirical soundness. So again, telling industry, look at what we've already done. We don't really need to reinvent the wheel, citing to the Federal Fair Credit Reporting Act and the Equal Credit Opportunity Act as examples to look towards. From a legislative perspective, we've seen the algorithm accountability legislation pop up. And here it's really getting companies to think about how they evaluate and implement AI. So developing processes and procedures to around training and what the impact of AI is going to be on fairness, bias, discrimination, and security. And even in those pieces of legislation from a liability perspective, they just reference you back to existing law. So the Unfair Trade Practices Act is the authority for enforcing those requirements. And then another example of where the US is sort of taking this more flexible approach, the National Institute of Standard and Technology, you may be aware of them from their work on the cybersecurity framework and the privacy framework, which are both good documents. They haven't gotten to that type of risk framework for AI. I don't know that it's ruled out. It may be something they're doing in the future, but they're right now really trying to understand how industry uses AI, what the issues are, and just really educate themselves about it before they go forward with what a framework should look like. So right now they have a request for feedback on an explainability document, really trying to understand companies should be able to understand the outputs and explain those to consumers. And then specific to insurance, which is sort of the state aspect of all of this, our National Association of Insurance Commissioners is very involved in this topic. They have a specific working group that is dealing with artificial intelligence, and it's tasked with understanding how it's used, but also developing guidance. And so from an insurance perspective, they just released what's called the AI Principles. It's supposed to be a high-level document that is create uniformity amongst the committees at the NEIC, so that if a specific committee is looking at specific applications of AI, they have at least from a principle level what the NEIC and regulators believe should be the underlying elements of those efforts. It was based on the OECD guidance, but they did not take any of the definitions from that guidance. So there is a little bit of concern as to how these principles are supposed to interact and how companies are supposed to use them. Nevertheless, they are out there, and the regulators do, even though they're voluntary, have an expectation that insurers are looking at them and figuring out ways to put governance around what those requirements are. So that's where the NEIC is. From a state legislative perspective, we have been seeing some of those algorithm accountability acts that we see at the federal level. Those will pop up as well. We saw them in California, New Jersey. So that's the background with which we're working in. It's, as I said, much different, very focused on trying to understand AI and promote a very innovative environment and not stifle advancement in this area. So hopefully that got to your questions.
Thank you very much. Thank you very much, Angela. I think you mentioned a very interesting point, and it's about looking over the pond and is there certain worries around it? Maybe within the U.S. insurance environment, looking at how strictly the framework in the European Union is pushed forward, or how is it perceived?
Yeah, I think there is concern, not just from an insurance perspective, but sitting in sort of our Chamber of Commerce conversations, there's an all industry concern about what's happening over in the EU and how that liability regime is developing for all the reasons that Fabian had mentioned. And would also point out, I think when you talk about compulsory insurance, when you start to talk about that in the US, you also then have the regulators put around underwriting restrictions and how all that is going to look. And so that really also impacts the risk appetite that companies are willing to sort of underwrite those products. So it's a big concern of what's going on across the world.
Thank you. So maybe in conscious of the time, and I mean, we could talk an entire day just about the different approaches, but I would like to move on a little bit to the policymaker, the insurance carrier's engagement within the entire framework and the industry. And so what I think would be great if you could both speak a little bit about the engagement you had with the relevant government regulatory bodies, and what I'm wondering is how informed and involved they are about insurability and liability implications of their proposals. If this is something that is up in the priority list when making this framework, and maybe were there any sticking points to the entire liability framework in these proposals? Maybe Fabian from the European side.
Yes, we're actively engaging, obviously, with both members of the European Parliament and the European Commission, and that's not something specifically related to liability, but we generally find that we have to, and to use a bit of a weird word, educate policymakers as to how insurance works generally. In terms of sticking points on this particular topic, I would say the compulsory insurance challenge is definitely an important point, because across the board, members of the European Parliament and officials in the Commission seem convinced that compulsory insurance is the way forward for artificial intelligence, and we consistently find ourselves explaining to them why this would result in a one-size-fits-all solution for a challenge that is actually extremely versatile. And yeah, stakeholders then always raise the example of motor insurance, which actually is very different. The motor insurance sector relies heavily on data that goes way back, and there's strong insurance capacity. The risks are also relatively similar across Europe, and this is in stark contrast to new technologies and artificial intelligence, where the usage, the appliances and the market is continuously evolving. So it would simply not be a right solution. And in a similar vein, also the opportunity of setting up a compensation fund is something we repeatedly hear from policymakers as a way forward. And obviously that comes with its challenges as well. And it's not necessarily, it would not provide accurate protection for any of the perceived risks related to AI.
So Angela, how does it look in the US? Do you have similar experiences, or is this different based on your approach?
Our experience has been a little different because they're not as focused on this liability issue. So the idea that insurance could be a solution hasn't come to their minds yet, and we'd like to keep it that way. But if that hasn't been an issue. I mean, from an insurer specific, like corporate use of it perspective, as we were developing the principles, there was a discussion at one point about putting a line in those principles that said, absent negligence, insurers wouldn't, before instituting liability requirements, you give the insurer the opportunity to cure and amend the problem before you start to bring enforcement action. So that did end up coming out because some of the regulators felt that wasn't appropriate for a principles document, but I think the sense there, at least for a majority of them, is that you should be able to cure before liability kicks in.
Okay. And from your end, or from your perspective, Angela, now comparing the two worlds and the two approaches, do you see any points in the US approach where might have room for additional improvement, or even that there could be something you would foresee to take over from the European Union approach that might be helpful to support your actions to get a legislative environment?
Yeah, I think what we can learn most about it is sort of taking the opportunity now to assess what those gaps might be so that we're prepared when those conversations do come. We're a very litigious society, and so I think there are articles out there that are already starting to look for what the liability regime is going to look like, and if we don't think about it now, considering what the insurance chief is doing, it's going to be forced upon us. And so I think the lesson learned there really is start thinking about it now and what it should look like, and leverage that discussion point that this isn't necessarily something new and you only should address the gaps. And so, you mentioned product liability. There's been some case law around, is AI a product? And if it's not, maybe you look at it as a service, and so we're looking at breach of warranty. So we're not still inventing an entirely new liability regime. We're just looking at what other aspects might be. So I think the lesson learned is start to look at it.
Okay, and Fabienne, from the other side, now being very restrictive in developing as European as we are, right, in making clear frameworks. Do you see any points of improvement or lessons learned we could take over from the US approach?
That's a good question. I think in terms of lessons learned, well, I mean, European insurers believe that the system is fit for purpose. Obviously, clarification of where of what the framework means for new and emerging technologies would make sense, and in that sense, it would be good to ensure that the existing framework is flexible enough in scope, so that insurers have the flexibility they need to tailor their underwriting. In terms of what we could learn then from the US approach, I think, we have repeatedly underscored to policymakers to make sure that they don't overlap and duplicate their efforts. As Angela also pointed out, it's actually good to have a look at what we already have. So yeah, that would definitely be something, and we've repeatedly called upon policymakers to do that, whether it's for cybersecurity or, in this case, artificial intelligence and liability. It's an important message.
Okay, perfect, and it perfectly bridges in the third topic, which I would like to get your input around. It's about harmonization, right? Now, living in a global world as we do, with a lot of new economy frameworks that doesn't care about borders or local individual frameworks, because it's platform driven globally at the moment. The website is online. How would you anticipate that? I mean, when you look at the current framework with a lot of local, individual, or maximum regional frameworks, how would you see that this drives us into gray zones and uncertainty, and might even hinder further improvement or development of these technologies? And how would you see could potentially, and that's my hypothesis here, a global harmonization might help to solve this, and how far away are we from that? So maybe Angela, your opinion first.
Sure. So I do have a fear that we could end up with a bunch of different standards, especially here in the US, different state standards. As I mentioned earlier, we do have legislation that we've seen in California and New Jersey, and even though it starts off looking like the federal legislation, there's always danger of it changing, and we see this in many areas. So I do see there is a fear for, even nationally, a lack of harmonization in this area. And while the NEIC, I think it was fantastic for them to have principles with the goal of creating uniformity, I don't know if at the end of the day, given how, like you said, there's no definitions, and how each of those there's room for interpretation in all of those, how that's going to work. So there is a fear that we could have some different standards, but I think that harmonization is important, and I usually think about it in terms of data security and privacy. can relate it to that, because we're talking about, when we're looking at sort of the algorithm aspect of it, at least, and the development and the performance of it, it's a business practice, and you're not necessarily going to change how you implement an AI algorithm across jurisdictional lines. And so if we don't have that harmonization, I think you risk stifling innovation and having companies sort of evolve and take the risk to try new things. So that's my fear. How we get there, I don't know. Hopefully it's continuing a dialogue amongst all interested parties and keeping this dialogue up with our counterparts. Your Insurance Europe is also very helpful. So those are my thoughts.
So it seems we're laying the ground for this global discussions. Fabienne, would you agree with this position, or how do you feel from European point of view?
Yes, well, I mean, I believe that, first of all, a certain level of legal uncertainty is inherent to the coming to market of new and even disruptive technologies. I think it's part of it. That's why the framework needs to be sufficiently flexible to make sure that actors can continue to cater to their customers' need. From a Insurance Europe perspective, I can say that liability is concretely a responsibility of individual member states, and there is a variety of different systems currently in place that work very well with in conjunction with the Product Liability Directive. So yeah, I think that's I think that's the level of harmonization we can hope for, and I think it works well as it is right now.
Okay, is there, before I see Pier Paolo is jumping, is flanking me from the side, just one quick follow-up, Fabienne and Angela, maybe to conclude this. Is there, we're talking now about that we should talk together, so is there some kind of global approach already implemented where experts and people started talking about this, or is it more driven like events as we do it today, where we exchange with experts, or is there an institutional framework on the go?
So I think it's sort of reactive that we have today, although I was talking to some of our NIST counterparts recently, and I raised the specific question of making sure that, you know, they're having these global conversations, and I do understand that they are. There is a dialogue between at least our representatives from NIST and those in the European Commission or Union, and so I think that there's at least a government dialogue going on. I don't know if, from an industry perspective, if we've gotten that same effort going. So, yeah.
Okay, cool. So thank you very much, Fabienne. Any comments on this from your end, or otherwise I would hand over to Pier Paolo to check if we have any additional questions from a Q&A perspective. Pier Paolo?
I think we have one quick question, but we have only 2 minutes, and then you have to wrap up with the conclusions in this 2 minutes. A quick question to Angela. So, could you tell us more about any litigation action relating to artificial intelligence algorithms that is happening now in the US?
So there hasn't been a lot of litigation so far in this area. Some of the issues we've seen, I think you're going to see patent issues starting to come through. Most of it's going to happen in usually the vehicle space, autonomous vehicles and software development there. So there hasn't been a lot, but it is something that we certainly anticipate there being more of. And I think another area that we may is this whole area of bias. While litigation didn't evolve from it, you know, a lot of the conversations in the federal legislation we saw came from the Amazon recruiting tool, where they found that there was discriminating against women in that. So I think there is a potential for some discriminatory actions that we could see as well.
So thank you, Angela, and please, Florian, wrap up the conclusion of this panel, please.
How long do I have, Pier Paolo?
30 seconds.
Okay, I speed it up. But first of all, I really would like to thank Angela and Fabienne. Thank you very much for the highly informative and engaging discussion. For me, the key takeaways, and Pier Paolo, I make it short. I think number one is we should not reinvent the wheel. I think even though AI is new and evolving, today's discussion has shown that it does not have to warrant a specific new liability regime, but we should actually learn from what is there already and learn from each other. I think while better legal certainty and guidance from regulators and legislators on certain gaps is required, and in terms of the policymakers' engagement, I think you both have raised that there is clearly an importance that our industry is represented and the insurance voice is held high in these discussions, because we are, I think, a very important element of this innovation journey, assuring that risk management is handled properly. And this brings me to the last point, that the harmonization to allow a certain level of legal security on a global basis would be very or will be an important key to allow these companies and the further development of this technology to rise in the way it actually could from a technical perspective, and is not held back by a local regulatory specific rules and guidelines. So with this, I would like again to thank you very much, and also to the audience. I hope it was informative. And with this, back to Pier Paolo. Thank you.
Thank you very much, Florian, Fabienne, and Angela, for participating in this session. Your comments and arguments were very instructive, and you provide a very comprehensive overview on the upcoming regulation in the EU and the US, similarities and above all differences. So now I give the floor to Judd Harris for his closing remarks. Please, Florian.
Yes, thank you, Pier Paolo, and thank you, Florian, Angela, Fabienne. I would like also to take this opportunity to thank all panel chairs and panel participants for this very intellectually stimulating session. I was reflecting on what we have been hearing and listening to in the past 2.5 hours, and two thoughts came to my mind. The first one is you are probably aware that we have launched this year a new work stream at the Geneva Association precisely for liability. Until 2019, we had a conference for liability topics, but we did not have a specific research work stream on liability issues. And all I've heard this afternoon confirms the need on these very complex topics to invest some thinking, some research, time and energy on the topics. I mentioned we would release a report by the end of the year on the topic of social inflation. Next year we will be working, not surprisingly, on the liability implications of the pandemic. We'll also be working in relationship to our last panel session on the insurability of new technologies and new business models. So all the things we've heard this afternoon confirm the need for some thought leadership on liability topics. The second remark that came to my mind listening to the different panel sessions, and particularly to the last one, I think I'm echoing what Fabienne said. There's a need to explain to policymakers the specificities of insurance. Insurance is not a simple business. It's a complex business. Very often, and we've seen that in the pandemics, particularly around the business interruption debate, very often the public policymakers and the general public more broadly do not understand what we're about. And we believe that as the Geneva Association, we have a role to educate the world out there, to explain the things we can do, the things we cannot do, the conditions under which we can protect people, businesses, and societies. And I think the discussions we've had today re-emphasizes this need to educate the world on the good things insurance can do, and also the limits, the things that insurance cannot do. Having said that, I realize we're 5 minutes later than the initial end of timing for this session. I would like to thank all participants for having attended this, particularly those who asked questions, and I look forward to our next liability conference in 2021. Thank you very much. Have a good evening or afternoon. Goodbye.